Gloria.
Welcome to the November 1st,
She always remembers me.
Public Service Commission meeting. And to start off with, I would like to ask Lisa Driggins to come up. Where's Lisa? Oh, there she is. I'm not sure exactly how you can get up here, but jump over or walk around. The commission would like to recognize that Lisa has been named the Employee of the Third Quarter, which is a great recognition for Lisa. And Lisa had done 2 years worth of volunteer work on the assessments and direct billing on behalf of the staff. And I tell you, we greatly appreciate her efforts. And we have here a very nice plaque indicating that she's the Employee of the Quarter, Lisa Driggins, and we all extend our congratulations and our thanks to Lisa. We do this some way.
There we go.
Sure how to do this.
You should be used to this. There we go. Perfect. Thank you.
Hold on for 1 second. Present. Well, welcome everyone. We have the reading of the meeting minutes of October 6th and the 18th. Are there any changes or corrections that any commissioner wishes to make to the reading minutes of either of those dates?
I'll move that we adopt the meeting minutes of October 6th and October 18th, 2016.
Is there any discussion on the motion to approve the
On the first one and the second.
Oh, that's right, yeah. All right, so I think, yes, I would do this. I can move to adopt the minutes of Thursday, October 6th.
And I second.
Is there any discussion on the motion to approve the meeting minutes of October 6, 2016? Hearing none, all those in favor signify by saying aye.
Aye. I'll abstain.
We have one abstention and nobody voted no.
You also
You have to
have to
abstain.
abstain.
And I'm abstaining too. I couldn't remember if that was the one I missed. Okay, October 18th is left.
All right, I move that we adopt the minutes of October the 18th, 2016 as presented.
Second.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion.
Abstain.
One abstention. Consent agenda. We have 5 items on the consent agenda. Does any commissioner desire to have one of the matters taken off the consent agenda and put to the regular agenda? Any commissioner have any motion with respect to the consent agenda?
Chair, I move that the commission adopt the consent agenda as submitted.
I second it.
Is there any discussion on the motion to adopt the consent agenda as presented? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion passes unanimously. Question to Mr. Howitt we have on the regular agenda. Number 1 is the, okay, I got you. Number 2 is the facility relocation charge. Okay. Let's continue on, I'm sorry. Number 1 on the regular agenda is the matter of the application of Delaware Power and Light Company et al. And it's a actually just a memorialization of the commission's findings and decision. So that's number one. Would the parties please come forward? Welcome, Mr. Shell. I think that Mr. Geddes is the one to lead this one off.
Mr. Chairman, members of the Commission, this is an order that does memorialize the discussion that was had on the 18th with regard to the final piece of the allocation of the most favored nation benefits clause that appeared in the amended settlement agreement. I believe it is consistent with the prior findings that the prior deliberations that the Commission had made in an earlier meeting. This has been reviewed by the parties, comments received, and I believe it's in a forum for your favorable consideration. Thank you.
Thank you, Mr. Geddes. Mr. Shell?
Thank you, Mr. Chairman, Commissioners. I agree with everything Mr. Geddes said. The joint applicants would ask that the order be entered as proposed, and we think it reflects your deliberations at your meetings of October 18th and September 20th.
Thank you, Joe. Ms. Ori?
Thank you, Chair. The public advocate is satisfied with the form of order. I understand there will be a longer order forthcoming at a later date that explains the Commission's rationale for its decision.
Thank you, Ms. Ori. Is there anyone else present that wishes to make any comment on any of the parties? A couple of the parties are not present. Any commissioners have any questions about the proposed order?
Move we adopt order number 8970 as presented.
I second.
Any discussion on the motion to approve proposed order number 8970? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes unanimously. Thank you all.
Thank you, Mr. Chairman.
Number two is in the matter of the application of Delaware Power and Light Company to establish a UFRC. We're to consider proposed order number 8971. The Commission welcomes Ms. Scott on behalf of Delaware Power and Light.
Thank you, Chairman and Commissioners. This order is to submit to the Commission the findings of the audit of the 2015 UFRC filing, the first filing that Delmarva made in connection with gas. And we have had the opportunity to review the findings of the audit and have reviewed the form of the order, and we are satisfied with the form of order.
Thank you, Ms. Scott. Mr. Willard?
Yes, Your Honor, as Pam Scott said, we agree with what she said, and also just point out the fact that this is the something that's allowed by Delaware law under Section 315 of Title 26. The UFRC can be imposed. In this case, it was imposed in 2015, and apparently there was some amount that was not collected, which the staff recommends go uncollected, and I believe all parties are in agreement that the order should be approved.
Thank you, Mr. Willard. Ms. Ivory?
Thank you, Chair Winslow. Commissioners, the TVA has nothing to add to the comments already made.
Any commissioner have any questions of the parties? May we have a motion?
I move that the Commission adopt order number 8971 as submitted.
Second. I second it.
Is there any discussion on the motion to approve proposed order 8971? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Ms. Scott, Mr. Willard, Ms. Ori. Number three is in the matter of the application of Verizon Delaware LLC regarding the safety valve relief. The Commission welcomes and is glad to see finally again Ms. Metz from Verizon.
Great. It's great to be here. Thank you. I'm here today, as you said, in connection with an application for safety valve relief. These are pretty rare for us. I don't know about the other carriers, but I think the last time we had one was 2014, and the time before that was 2009. But just a little, so if you indulge me, I'll give you a little background on it, because I don't know that you've have encountered them too often. When the telecommunications market was opened up to competition, one of the things that the FCC wanted to make sure was that the numbers that were going to be given out to the carriers were given out and used in an equitable basis, so that one carrier didn't get a great block of numbers or get numbers that they weren't even going to use and hold on to them for a long time. So they created a numbering administration that basically gives to the carriers certain blocks of numbers, and when those thresholds are met or utilization, the carriers can then go back and apply for new numbers. So that's the process that goes on at the federal level. But at the same time, the FCC also granted to state commissions the ability to grant relief and to give out numbers in cases where there's a specific customer that's requested a block of numbers, but the inventory for the carrier isn't great enough to meet that request. So in this case that's before you now, we have a customer that has requested 3,000 consecutive numbers from us that we do not have those consecutive numbers. So we made the request, as we're required to do, of the numbering administration. They denied the request because the utilization isn't high enough for them to just grant us new blocks of numbers. So we are here before you today to ask that those numbers be granted from the State Commission.
Thank you, Ms. Metz. Mr. Willard?
Yes, we agree with what Ms. Metz said. Also, as she said, the federal authorities rejected this request because of the terms that Ms. Metz pointed out. And in order to get it, the state commissions are permitted by law to grant this request, but they have to show, the applicant has to show compelling and permissible need for the numbers. They have to describe why granting the numbers won't run the risk that the numbering resources will be inefficiently used. They have to provide written evidence that the NANP has rejected their request, which they have done, and they have to describe any long-term impact, which they explained to us there should be no long-term impact. The staff has reviewed all of this. They felt that they met the requirements of the law, and the staff agrees that this should be awarded.
Thank you, Mr. Willard. Ms. Iori?
The public advocate was not involved in this proceeding.
Okay. Any commissioner have any questions of the parties? This is a pretty standard request. It doesn't happen often, as Ms. Metz said, and the staff has indicated that Verizon has met its burden of proof with respect to the legal parameters. So we have a motion to...
Before the motion, there's a word missing on the third or the last paragraph on page 3. It's the valve, but it should be in there. In the first sentence, it's network across the country, so that should be added to the order.
Why don't you make the motion and incorporate that as part of the motion?
Motion to adopt order number
I'll second that.
8974 with the word added on the first sentence of the last paragraph on page 3.
Thank you, Commissioner Drexler.
I'll second.
Any discussion on the motion to approve the proposed order number 8974 with the revision as stated by Commissioner Drexler? No questions? All in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion passes unanimously. Thank you, Ms. Metz.
Thank you.
Mr. Willard. Okay, the next is our hearing schedule, and we have, in the matter of the adoption of rules and regulations to implement the provisions of Title 26 of the Delaware Code, Chapter 10 relating to the creation of a competitive market for retail electric supply service. And we've got to make some decisions in this one. So I assume that we're going to have Ms. Iori and Mr. Green. Have we have Mr. Green lead off for the RESA?
Sure. Brian Green for the Retail Energy Supply Association. Good afternoon, Commissioner, Mr. Chairman, Commissioners, and this is a happy day for the Commission. This is a good day, so I want to get that out there.
The commission determine that?
Okay.
After
have
more than
agreement
4
on that.
years of trying to revise the current Delaware electric supplier rules, we have, as you recall, a month ago, been able to publish a version of the rules which was proposed and presented by DPA and RISA. That was published on October 1st in the Delaware Register. Since then, the parties have met and been able to narrow the issues even more. Today, we present a red line of the October 1 published version, where we were able to come to agreement and tweak the language. There are still two undecided or non-consensus issues, but I want to table those for a moment and talk about the consensus items. I think it's important that the Commission get a good sense of what's in these rules. There are a world of substantive provisions that are not currently in place in Delaware. These rules would totally replace the current rules, and they not only add detail to what currently exists in Delaware, but they bring brand new provisions to Delaware. And in going through this, I want to backtrack a bit and say that for the four primary stakeholders, staff and the utility and DPA and RISA, to be able to come together on all of these consensus items, every issue but two, is something we should all be very proud of. If you go back and look at the comments that were filed throughout the history of this case, you will see just how far apart so many of the parties were, especially RISA and the public advocate, which you could argue are really the two stakeholders in the case with the most to lose and the most to gain. What we tried to do in coming together, RISA and DPA especially, was balance the need to safeguard customers all throughout the electricity shopping process. At the same time, not impede the development of the market and in a sense, to encourage the development of the market. So how do we get that balancing act? And we feel like the rules as presented today with the red lines get there and keep everyone in check. And I want to go through some of the highlights. I'm going to try to do this in a sort of 30,000-foot level, but I have a tendency to drop down in the details. So if you want to stop me and ask questions or tell me to move forward, or if I see that your eyes are glazing over, I will do my best to speed it along. But,
why don't you start out at 50,000? That way, if you get
okay.
down to 30,000.
So one of the key components in the rules is that there are additional licensing requirements when suppliers come in and ask for a license to serve Delaware customers. That's all in Section 2. There are significant additional requirements that suppliers have to bring to the table, so to speak. Everything from managerial capability, financial integrity, which includes a bond, which is an ongoing bond now, and then how you can post your financial requirement. Those were, I don't want to say fairly contentious, but those were significant issues of discussion, and we were able to get past all that. And I know staff, especially if I can speak for them, views Section 2 as an extremely important section, and it is. And I think we were able to get 100% consensus on that, which will increase the knowledge level that the Commission and staff has with the suppliers, and ensure that you have information on an ongoing annual basis from suppliers. And staff may want to add to that when I'm done, but I just wanted to make sure we pointed out that we've cleaned up that section and added a lot of beef to it. One of the greater goals of the rules was to ensure that customers have additional information every step of the way, whether it's in the marketing phase, in the enrollment process, when you're actually signing up, whether it's online or at your door or at a kiosk in a mall, and that you continue to receive information after you've signed up, so that you understand every step of the way the product that you're considering and the product that you've contracted for. And that if you have to do something affirmative after you've signed up, you get a notice that tells you exactly what you need to do and what happens if you don't do it. And we'll go through that in a moment. But that's from a high level. Now, how do you, in a marketing perspective, for example, in section, and we don't have to turn to it, I just want to throw out for the record that 11.5.1, in certain instances when suppliers give their marketing materials, they have to have a table on the marketing material that tells you what is your monthly price going to be if you're at 500, 1,000, or 2,000 kWh per month. So customers can see the rate impact of what it is that they're looking at. In the contract itself, there are certain disclosures that suppliers now would have to make to customers so that they understand what it is they're signing up for. A few examples, and this is specifically relating to variable price contracts where you have a price that can change every month. And you may flash back to the 2014 polar vortex where there was a dramatic increase in wholesale prices that filtered down into the retail variable monthly pricing contracts, and a lot of customers paid big increases in their kilowatt hour pricing. And the problem after the fact was that, one of the problems was that customers not only didn't know that their rate could increase that much, but they didn't even know their rate could change on a monthly basis, even though they had signed up and there was nothing inherently wrong with the process that they went through. The supplier didn't do anything wrong. The customer didn't understand what they were signing up for. So what we tried to do was build things into the disclosures pre-contract that would take that into account and make for a better educated customer, such as in the contract, if you have a variable contract, you have to have disclosures that say this is a variable contract, and if there's no limit on how much the price can change, you have to say there is no limit on how much this price can change month to month. You have to provide historical pricing, 24 months worth of your historical prices in the contract. And this is all in Section 6. That if you don't have 24 months historical pricing, you give whatever it is that you have. And then there's also, importantly for RISA, a disclaimer that says monthly or historical pricing is not indicative of future pricing, because there may just, you could have flat variable prices and then something happens in the market. But a customer can get a good idea of how often that supplier's prices may change or how often it has changed in the past. We're also introducing the concept in Section 6.3 of a contract summary, which many other states are doing this now. It's been proven, I think, very helpful to customers to understand the really material terms of what they're signing up for. It is very similar to a Schumer box after Senator Schumer from New York. If you look at your credit card bill, you'll see the little box that has all your interest, whatever percentage information and things like that. That's the concept that for electricity is to have a box or a summary that tells you, what's the duration of your contract? Is it how often? What's the first month's price? What's the fixed price if it's longer than a month? It has all of those terms in there, so you can readily see the real high points of your contract. And I would add that a lot of the variable disclosures are required to be in the contract summary as well. The rule also provides when you must give the customer the contract summary, because there's different enrollment or different marketing channels. It could be door-to-door, it could be over the telephone, it could be online, and so forth. More upfront disclosures. There's a new definition for a third-party verification, a TPV. So if you're signing up on the phone, for example, you have the sales portion of the call, and then we've all done this, right? At some point at the end, after you say, I agree, they say, okay, I'm going to flip you over to this other person. They're just going to verify that you really do want to do this, right? So there's a new definition for a TPV that includes specific questions that the verifier would have to ask you and have to get an affirmative response. And I would also add, in that definition, is that if the sales agent transfers you over to the verifier, the sales agent cannot remain on the phone. So there's no coaching. There will be no misunderstanding that the customer wants to sign up with that supplier under these terms and conditions. So, so those are examples of the upfront disclosures and disclosures that you get during the enrollment period. So then there are greater disclosures during the term of your contract, including if you have a contract that renews automatically. You may have a 12-month contract that if you do nothing, it will renew to another 12-month contract, or it could renew to a variable monthly price. But the rule ensures that you will get notice before, I think it's 35 or 45 days before the end of your fixed price contract, which is in Rule 8, that will tell you, the rule prescribes exactly what you need to say in that notice, what the supplier needs to say in that notice, And then if it renews to a variable, you have additional disclosures that you have to make. So if the customers understand that if they do nothing, here's what's going to happen, here's how they can get back to SOS if they want to, and here's how to contact the supplier if they would like to terminate the contract. There are additional disclosures if in the course of your fixed price contract the price changes, if there's a regulatory out provision, as they call it. An example off the top of my head is if the FERC totally overhauls the capacity market and wholesale prices go up for everybody. Many of the retail contracts have provisions in them that allow the supplier to pass that increase as a result of that change in regulation through to the customer. So there are ways that a supplier can notify the customer, and the supplier can get out of the contract if it wants. I mean, the customer can get out of the contract if it wanted to. There are additional disclosures if just the contract is ending and no one wants to. It's not an automatic renewal contract; it's just ending. You will get a notice that says specific things. And then finally, for variable contracts, one of the issues in the polar vortex and with any variable price right now is that customers don't necessarily know what their next month's price is going to be, right? So sometimes they don't know until they get the bill. So the new rule requires a supplier to give what we call the 12-day rule. So 12 days before your new price will become effective, you can access your next month's price. So what that means and how you access it is a matter of contract. It can be on a website. It can be by telephone call. The supplier can text it to you. Whatever you can agree to with the supplier, but how that method occurs must be in the contract. So if you don't know, if the supplier doesn't know the price 12 days ahead of time, they have to provide you with an estimate, and the actual price cannot exceed the estimated price. So suppliers that don't know 12 days ahead of time, if they give you this really big estimate, really high estimate, you're going to leave, right? So, and this works hand in, and I'll get back to this, but this works hand in glove with the new accelerated switching rule. Because under 3 business day switching, you find out your price, you think it's too high, you don't like it, you have time to leave, to shop and to leave for another supplier or come back to SOS before that new price becomes effective. So these are the types of in-contract notices and new information that customers will get in order to take greater control over their energy prices and products. There are additional procedures with respect to marketing channels, such as telemarketing and door-to-door. Telemarketing is in Rule 11.7. There are mandatory representations that suppliers' agents must make when they call you on the phone, such as, my name is, I'm working for this supplier, here's what I'm selling, I am not with your utility. So before you can move on, you have to make those representations. And I'm paraphrasing because I haven't turned to the rule, but that's the gist of it. So importantly, for telemarketing calls, suppliers will be required to record and maintain both the sales portion of the call and the TPV. In many states, it's one or the other. So there's suppliers that don't record their sales portion of the call, they'll only TPV it. So if there's ever a problem with the enrollment, you don't have the sales call. You only have the TPV. These rules require the supplier to record both the sales call and the TPV and maintain them both. With respect to examples of door-to-door, first it clarifies that the new rules would clarify that the supplier needs a written or electronic authorization plus a separate verification, which many times will be a TPV, but there are suppliers that verify it differently using a different method. The important part about that is that if someone comes to your door, you sign the contract either in writing or with your finger on a tablet or whatever the case may be. When you do that separate verification, the agent cannot be present on your premises. So there's whatever intimidation factor that might exist with the agent standing right there while you verify that you really do want to sign up for this product is absent because the sales agent is required to leave. just as in telemarketing, there are required representations that agents in door-to-door sales must make to the customer. And then there is also the requirement of a photo ID badge, which I learned during the process that under the Delaware Home Solicitations Act, the door-to-door knockers must get a badge from the Delaware Department of Revenue, I believe it is. These requirements in the rules today go beyond what the Delaware, what the State Department, the Department of Revenue gives to you, because there's additional information on the badge and there's a photo on the badge that you don't get through the department. So actually, suppliers would be wearing two badges. So, and then finally, there's a requirement for a criminal background check for door-to-door agents, which the rule spells out in exactly how you would do that background check. State and local, a federal check, a sex offender check, and then existing agents would have to be, I think the suppliers would get 90 days to perform those checks on existing agents that might be in the field today. And then finally, the Rule 10.4 requires suppliers to train their agents. This is all agents, and agents is a capital A. It's a defined term in the new rules. There are 11 different topic areas where suppliers must train their agents, and they must provide copies of the documents used in the training to the DPA and the Commission upon request. I'll just say that when I advise my clients about training, there's the training materials that they use, whether it be a slide deck or PowerPoint, whatever. But then we advise, have your agents each sign a certification that they completed the training and keep that certification. And that's the kind of thing that if there was ever an issue, heaven forbid, the supplier would produce the training materials and the certification that this particular agent completed the training. And then finally, I mentioned 3 business day switching earlier. That this is a significant customer protection and also good for the market. The idea right now, I mentioned earlier, that if you want to switch your supplier, you have to get the suppliers to get the request in either with 15 or 17 days, I can't remember, before your next meter read date. So if you miss that day by one day, if you miss that deadline by one day, you could take up to 5 or 6 weeks to effectuate a switch. So what happens is customers want to be able to move. They want to be able to take advantage of products quickly or get away from a product quickly. And if they can't do that, that's very frustrating, makes for a negative shopping experience. And when suppliers explain to them, well, that's just the way the rule is, that doesn't, either they understand that and it still makes for a negative experience, or they blame the supplier and they say, I can order food and have it, from Alaska and have it on my dinner table tomorrow night. I can go on my phone and transfer money. You can't switch my electricity account in 6 weeks. So you are so technologically inferior, you can't do this. So it's getting that number down to 3 business days is extremely important and a benefit to all stakeholders. And so that's the high level. There are, as I understand, the non-consensus items. There is an issue over the rescission period, which is not. There's 2 issues with the rescission period. One is in play today, and one is a consensus item. So, the one issue is how long is the rescission period? Is it 3 business days, which is in the proposed rule, the published rule, or is it 7 business days, which is staff's preference? The other issue, the other thing to say about the rescission period is that there was an issue of when does it start. The rules address that, and we're all on the same page on that. It's actually, and when it starts has to be in the contract. Something to point out. But one thing to decide today is, should it be 3 business days? Should it be 7 business days? And I'll save my argument on that for later. The second issue deals with customer lists in Rule 3.3. The proposed rule, the published rule, would enhance the amount of information currently available in the Delmarva list. It would keep it opt-out. Delmarva would be required to update the information on the list every month. So if customers moving, new service, people leaving the service territory, all that would stay fresh and current. And then also, you could opt out of the list. Your opt-out election would be valid for 1 year. Delmarva would send an annual notice. And so you would opt out this year. You get your notice next year. You would have to opt out again, or you would be back in the list. So every year we start at ground zero, so to speak. The issues, as I understand it, is for the commission today, with respect to the list, is number one, should it be opt-out or opt-in? And then second, if it's opt-out, for how long should your opt-out election be? The rules is 1 year. I believe staff in Delmarva are proposing a forever opt-out. And then second, with respect to the list, with an opt-out list is what information should be on the list. It's very important for RISA, and what's in here in the rule is that we need to have, well, I'm getting into argument, so I just wanted to tee those non-consensus items up. But that's an explanation of what's in the rule now, and the additional information they give to customers and the proper balance that it creates between protecting customers and allowing for the development of the market, and then the two non-consensus items that we have today.
Thank you, Mr. Green.
And I'm happy to.
Are you going to tell us
There's no
about?
questions. I'm
Are you going
happy
to
to-
tell us about the contested ones?
Sure, I didn't know if we wanted to have, if there was going to be any discussion, or if I missed anything on the consensus items, anything anybody wanted to add.
I think you're basically still part of your opening statement, so if you want to continue and
Sure.
talk about the issues, that would be appreciated.
Sure. So taking the rescission period first, what I have to say today is really no different than what is in the comments that we filed on Friday. The RISA and DPA and what's in the proposed rule is a 3 business day rescission period. And bear in mind, what happens is the supplier has to wait out the rescission period before it can submit the electronic transaction to the utility for the switch. And then under the rule, the utility would have 3 business days to process the switch, right? So in RISA's view, you've got a 3 business day rescission period, which is consistent with neighboring jurisdictions, state law, and federal law. And if the idea is to compress that time period for a customer to move when they want to what they want, then it should be as short as possible. For neighboring jurisdictions, Pennsylvania has a 3 business day rescission period. The District of Columbia has a 3 business day rescission period. Maryland does not have a rescission period outside of it has one in its Door-to-Door Sales Act and the federal cooling off period, which is in the CFRs, but they do not have a electricity or natural gas rescission period in their rules. They specifically say that they don't have one. Those have been fine. We are not aware of any problems that have arisen because of the 3 business day period, and they've been in effect in D.C. for some time, for Pennsylvania for, I don't remember, I think it's been several years. But and then as far as state law, the Delaware Home Solicitations Act, which is the Door-to-Door Act, basically requires a 3 business day rescission period. So, and it's consistent with the federal cooling off period, which specifically applies to door-to-door. And there's under each of those, there's notices that you have to give to the customer, which says you can cancel this within 3 business days of the transaction. So if we had a different one, we'd have to give the customer actually 2 notices, one that says 3 business days and one that says 7. We feel like 3 business days is fine. That's what other states, Pennsylvania, the Door-to-Door Act is 3 business days. Maryland is 3 business days. So the neighboring jurisdictions are all coming together, so to speak, on a 3 business day and making their electricity and natural gas rules consistent with the door-to-door rules. And there's been no reason that I'm aware of to make electricity a longer rescission period than any other product out there. And then finally, on the issue of compressing that time period, So under RISA's and DPA's proposal, customers would have a 3 business day rescission period followed by up to 3 business days to process the switch. So you're looking at 6 business days to make a switch of your electricity supplier. Under staff's proposal, you're looking at 7 business days plus 3 business days to process the switch, which could be 10 business days, which is really 2 weeks. So you're looking at the difference between conceptually 2 weeks versus 1 week for a customer to make really what is an informed decision when they have all this information about the product in front of them. And if they don't like it, even after they sign up, they can get out quickly as well. So our view is that 6 business days is better than 10 business days. And if the idea is to allow customers to have what they want when they want, then we should go with the 3 business day rescission period, consistent with other jurisdictions and with state law. So that's my argument on the rescission period. If you want to hear from others now on that issue, and then we'll go to customer lists after that, or if you want me to keep plowing ahead.
Let's finish.
Okay. All right.
We don't want to hear from you again.
Right. No. Okay. So customer lists. In section 3.3, the current, well, let me just say this. The current rule in 3.7 is an opt-out list and requires Delmarva to give 3 data points, which is the name, the service address, and the billing address. I think Delmarva in practice actually provides more than that, but they, importantly, they do not provide, and what would be in the current rule is usage information and the account number and the 22-digit service number, but I'll get to that in a minute. So if you work your way down 3.3, you'll have the first issue, like I said, is opt-in versus opt-out. We think opt-out is very important. Delaware's already decided this back in 2006 under the current rule, which is opt-out. Other states are all utilizing opt-out lists in some way, shape, or form. I've cited to some of them in our comments from last Friday. Pennsylvania, Virginia, although it does have very limited shopping opportunities, but they went through the process. They adopted an opt-out list with substantial amount of customer information. And interestingly, if you're a licensed supplier in Virginia, you can go on Dominion's or Appalachian Power's website and get a plethora of information on over 3 million customers, and there's never been problems that I'm aware of at the Virginia Commission about this. Same thing in Massachusetts. Maryland for BGE allows opt-out lists. And, of course, Pennsylvania is opt-out. Pennsylvania, in deciding opt-out, ruled that opt-out was an efficient way for customers to withhold their confidential information. And in our view, allowing for opt-out better meets the legislative purpose of providing efficient access for customers to competitive options. So we feel like there's no reason to deviate from opt-out. I think staff is on record of saying it should be opt-in. I'm not sure where Delmarva is on that issue. I know where they are on if it's opt-out, what information should be there, and so forth, but I'll let them comment on that. Also, with respect to opt-out, there's no evidence that I'm aware of anywhere that an opt-out has caused any problems. And 2 things to point to on that, and I'll come back to this in a moment, but Pennsylvania has a division within the commission called the Office of Competitive Market Oversight. They have opt-out lists for over 6 million electricity and natural gas customers. I spoke 2 weeks ago with the director of the division. He confirmed what many of my clients say is that there's never been a problem in Pennsylvania with the opt-out component of the list, with protecting and safeguarding the information that's available in the list, that they've been doing this for a while, and there's never been a systemic or widespread or pattern of problems that have developed because of this. In full disclosure, he mentioned there have been a few isolated, scattered incidents, but he did not consider them to be significant, and that he said, importantly, there have never been any enforcement actions based on a supplier's misuse of a customer list. So, and then second, in the rule itself, in Rule 3.3.3, we worked with the stakeholders to develop the whole 3.3.3, which speaks to safeguarding the information in the list, how suppliers are to maintain the list, who they can share it with, that they need to have authorization from the customer in order to share it. Even internally, they can only use it for providing electric supply service for marketing purposes. So it's a very carefully worded and protective measure for customers. The next issue is the timing of, if you opt out, for how long should the timing be? And I think we have, what we're seeing in Delaware now is that it's opt out, but when a customer signs up for service, they are told they can opt out. Approximately 1/3 of customers in Delaware have opted out of the list over the last 10-year period. So and they're never asked, again, they're never given a reminder that they can get back on the list. They're never given any notice of what they've done. And what it is made for is a very stale, less useful list because it's missing so many names. And with respect to the timing, Pennsylvania looked at how often should they be updated and felt that periodic updates are in the best interest of customers because it reminds them that they can get back on the list. It reminds them that there's a competitive market out there, and they may want to receive information about it. Also, in the last 10 years, quite frankly, the market's changed quite a bit. There's a lot more suppliers out there. There's a lot more products out there. And the idea is to get more of that here in Delaware. And if this goes to safeguarding of the information, if there's a question with confidentiality, again, the rules provide for all that. And one other thing I want to add on safeguarding the information, whatever people overlook this, whatever rules there are out there that apply to the utilities handling of information that they receive, proprietary, confidential information, those same laws also apply to suppliers. So if there's a federal rule, if there's a federal law, state law, cyber issues, whatever, suppliers come under those same laws. So it's not like not like suppliers are operating with respect to maintaining confidential information in some wild, wild west. Right? There's a pretty robust provision in 3.3.3, but I just wanted to point out that whatever statutes there are out there also apply to suppliers. And then finally, there's an issue of what information should be included in the lists. And I want to take a step back for a moment to talk about how important the lists are. And the more information, the better for suppliers, because it helps them to design new and innovative products because they can see what the usage information is, what the trends are, and so forth. It also helps them to control their overhead and their own costs. By being able to control and get a better feel for what their wholesale procurement practices can be, it's very possible that they can offer lower prices to customers. I'm not guaranteeing it. I'm just saying that it's out there. It's one thing I've heard in the market, and it's one thing that came before the Pennsylvania Commission, which they had in one of their orders as a consideration for putting more information in the lists. And then thirdly, a list with the account number and the 22-digit service number, that's really important because it is a serious market impediment to sign up a customer when you don't have the 22-digit service number, which Delmarva implemented about 1.5 years or so ago. So, and if you're a supplier and you want to set up a kiosk at a mall, or if you want to have a table in front of a big box retail store like a Walmart or a Target, it's really hard to do that if you can't get the information from the customer in order to sign them up. Right? You don't memorize your 22-digit service number, and you don't walk around with your electricity bill. But if the supplier had access to a secure web portal and could look up that information, assuming the customer hasn't opted out, it will smooth out the enrollment process, allow the customer to take advantage of the product that they want faster. So that's generally my arguments on the opt-out versus opt-in, the timeliness of the periodic reminders of opt-out, and the importance of having usage information and account number and service number on the available in the lists. And I'm happy to take any questions the commission may have.
Thank you, Mr. Green. Ms. Iori?
Thank you, Chair Winslow and Commissioners. I don't have anything to add to the substance of what Mr. Green has already told you about the proposed rules. What I did want to point out, because I think it's really important, is that these rules were primarily drafted by RISA and the DPA, and as Mr. Green indicated, we were probably the most diametrically opposed parties if you looked at our comments over the course of the 4 years that this proceeding has been pending. And I think the fact that RISA and the DPA were able to reach consensus on so many of these items, I think speaks volumes about, well, one, the collaboration and the compromises, but it was always the DPA's intent to have as much customer protection as necessary without basically putting so much in there that shopping would never happen. I mean, it's possible to over-regulate and turn into, as some of my Republican friends have called it, a nanny state. We really didn't want to do that. We wanted to give consumers the option, but we also knew of abuses that had taken place in other states. And we fought very hard to get protections in there to hopefully prevent those sort of abuses from occurring. And I think that we have accomplished that. Lastly, I would say what we've got basically is a settlement, except on two issues that Mr. Green has discussed. I cited to you in our comments the Constellation New Energy case, in which the court gave the public advocate's position on the settlement a great deal of weight, because the public advocate is tasked with protecting residential and small commercial customers. We believe that the rules that are before you now adequately balance the need to protect customers from problems that have occurred in other states, and to encourage shopping as our General Assembly has decreed. So with that, if you have any questions for me, I'd be happy to answer them.
Thank you, Ms. Ivory. Ms. Scott?
Thank you, Chair Winslow. Delmarva issues essentially focus on Section 3 of the rules, and it's with respect to the customer list component and how that is addressed. And specifically, with respect to the whole process of whether a customer is on the customer list or not, just as a reminder, the customer list is the marketing tool that the suppliers use to market to potential customers. I think the Commission determined back in 2006 in Order 7023 that this would be an opt-out process, so that customers would be given the option of opting out of the list if they did not want their name to appear on the list and they did not want to have suppliers marketing to them. So Delmarva has honored that as part of the process of dealing with customers. When customers first apply for service and we describe all the specifics of that service, what we discuss with them is whether or not they want to have their name included on the list for marketing purposes so that they can be contacted by third-party suppliers. That has been the case ever since late 2006, early 2007. And what we have done is we have honored what the customer's request is when they were asked how they wanted to be treated. They certainly always have the option of coming back and telling us, okay, you can take me, I'm okay now. You can put me on the list if you want to. What is being proposed now is not only that they would, now they would have to basically every year make an affirmative statement as to whether they want to be on the list or not. The concern that we have is that how we communicate to our customers, generally speaking, is through bill inserts. And oftentimes in your bill insert with your monthly bill, you're probably going to get more than one. And the concern is that all of this process can get lost in the shuffle, and the customer doesn't realize that, oh, I probably should have opted out and I didn't do that. They find out at some point they're starting to get calls, people showing up at the door, and next thing you know, we get the call, well, Delmarva, why didn't you, what are you doing? Why am I on this list? So our concern has been that we sort of have this relationship with the customer when they first sign on, that we are going to maintain what they've told us they want. That also goes with respect to the information that they provide us, their personal information about what appears on that list. And we are concerned that if you're now changing the process so that now every year they're going to have to affirmatively tell us what they want to do, it's going to get lost in the process, and we're going to have customers that are not going to be pleased with how this turns out. We think that people pay attention to these issues when they sign up for service, and that's why that is the point in time when we have the conversation with them. And as I indicated, they always have the option to come back at any point in time and let us know by calling customer service or via the internet to tell us that they have changed their position and now they're okay with being on the list. So that's the one issue that we have. The other issue about the list is currently we provide the information that's required by Rule 3.7. We actually, as Mr. Green indicated, supply a bit more information than what is required by the rule, but we update the list about twice a year. What is now being requested is that the list be updated on a monthly basis. We believe that is going to obviously create a lot of additional work for us, but it's also not particularly necessary. We believe that twice a year is probably enough. We even had talked about potentially doing it quarterly, but monthly we feel is a bit of overkill in this process and really not necessary for the marketing process to be successful. Beyond that, in terms of what is actually appearing on the list.
Excuse me, Ms. Scott, just while you're on that, I'm not sure I understand the updating situation. Do you go in, actually look at every customer at some given point in time and update it? Or do you do it seriatim? Every customer, the customer calls in, you get the information, and so it's continually up to date. How does it work?
If I may, I have with me, and I neglected to introduce Natalia Mathora, who is the manager of Energy Supply Services for Pennsylvania. She can probably more appropriately answer that question than I can.
Good afternoon. We update.
Excuse me, Mr. Howard.
Chairman Winslow, this is an evidentiary hearing, I believe, and I guess the question in my mind would be, aside from attorneys and other parties speaking, should they be sworn in for the record?
Well, I think that's a good point you make, but we're basically just having opening statements at this point in time. I'm just asking for some clarification on this of if we do this without going through that procedure. And if there's going to be testimony presented by a party, then obviously we'll have someone sworn in. But this is just a clarification of that argument.
Thank you, sir.
This is considered part of the argument. My question is, do you update it continuously so that you always have an updated list, or do you at some point in time in the year decide, okay, we've got to update our 300,000 customers and somehow do that at one point in time?
So there's a database that holds all of the customers that that have opted out of this particular list. And when we run the list in April and October each year, it basically hits that database. So the database is always current with the list of customers who want to be excluded. And then the lists are posted to a secure website in April and October.
Thank you. Thank you, Ms. Scott.
Sure. The one last point where we have a difference of opinion is the information that is actually included on this list that's used for marketing purposes. Again, there are some items now that we provide, but there are a number of additional items that RISA has requested, and we have some concern about that because we believe that this is personal identification information, personal to a customer, and we have some discomfort about providing that information. That includes the account number, that includes the historic usage on the account, That includes the on-peak and off-peak consumption on the account for a period of time, things along that nature. Again, this is all information that we gather from a customer that we are required by various requirements to keep very secure. We consider that personal to the customer, and we have a discomfort about providing that information, having it out there for third-party suppliers to have available, and we just believe that what they have now is more than adequate for them to continue to market to customers. Thank you.
Thank you, Ms. Scott. Mr. Geddes?
Thank you, Mr. Chairman and members of the Commission. Staff supports both points that Ms. Scott made with regard to the customer list. I believe that Mr. Green, in his comments about customer lists, used the word refresh and update, which I think is a little bit of a euphemism. In Delaware, everyone is in. So based on your decision in 2006, I actually wasn't aware of, which I participated in the case, but I didn't realize that the Commission had actually said that all customers were in the sense of that information would be given to the suppliers. I was quite surprised that we had actually agreed to do that. So the question before you is not opt-in or opt-out. It's like the polar vortex. Polar vortex only happened because it was negative, not because it was positive. But in any event, I digress. All you are doing here is, in essence, preserving the status quo, if you agree with DP&L and with staff. It's like the national don't call list. You don't have to be refreshed or reminded or whatever. You say, I do not want to be called, period, by this particular vendor. And that's the end of the discussion. The point I made through some of the workshops is that with the electronic age, a lot of us get our bills, we found out what the number is, we plug the number into the computer, and we throw the rest of it away. Now, Delmarva is very good about having lots of inserts, and I think their concern is that the insert that says, well, you have to do something in a month will probably end up in the circular bin, and they won't read it. And so why should the status quo, the customer saying, I do not want to be part of the solicitation, be changed at some arbitrary date because the suppliers believe that it's in the customer's interest to be resolicited? Talk about a nanny state. I mean, in essence, you're telling the customer that their original decision is not valid after some period of time. And staff disagrees with that. If somebody's made an affirmative election not to be on the list, then they shouldn't have to renew that decision every year, every 3 years, or every 4 years.
So that option given to them by Delmarva at some given point in time, and some customer makes up their mind and they opt out, that's very reliable. That's something that the consumers are doing with the knowledge of all the facts and that they understand that they could call back. I have some real doubts that I'm sure obviously customers are opting out because 36% of them have since the last 10 years, and I guess more opt out along the way, so that we have less people in the marketplace for retail supply than we have right now. I'm not sure how knowledgeable these opt-out are, and what's wrong with giving them another chance to look at the alternative suppliers and the competitive models and say, okay, let's...
And that's perfect, and that's called notice. That's called putting a flyer into the bill and saying, are you aware that these additional services or suppliers or whatever are available? That's consistent, I believe, with what you just said, Mr. Chairman. What they're suggesting is that the decision that was made by them not to be on this list is now going to be reversed for everybody. So the 10 customers, 20 customers, 30 customers who, after some period of time, want to, perhaps change based on a notice, well, that's one thing. But you're in essence saying wholesale, everyone who's opted out, that 36%, now is in again.
it's difficult to market to the 36+% who've opted out if you don't know what their names are, how to contact them, isn't it?
Well, the point, I believe, is whether you think it's appropriate at some period in time to take those people that have made an affirmative decision and, in essence, cancel it. And obviously, you can disagree. Staff disagrees, and perhaps the commission believes that Risa's position is a better position.
So Delmarva tells these people, look, if you opt out, we're not going to let you know about any beneficial programs that are coming down the line. You're going to have to call us. And how thorough is that whole thing done? I mean, do you examine that as thoroughly as the door-to-door solicitations and the telephone solicitations, Mr. Geddes?
Based on the prior precedent, I think Ms. Loper would like to make a clarification.
I think she made some indication that she'd like to, so we would welcome to hear from Ms.
She'd like me to be quiet.
Chairman, so Commissioners, I would say that, I'm a Delmarva customer, SOS customer. I opted out of the list, and I think a lot of folks are in my similar position. Just because you opt out of the list doesn't mean you can't go shop. There are mechanisms in place. The Commission has a web page where we list electric suppliers who are currently, in marketing in Delaware. And if a customer is so inclined to go out there and shop on their own without being marketed to, they can do that. But I think that by telling the customer that, if you don't affirmatively opt back in or opt out of the list during the refresh period, you're just going to be marketed to. I think much like Delmarva says, you're going to have customers who are upset that they missed that refresh period and are now being marketed to when they don't want to receive those active, door-to-door marketing tactics that come to their home.
Why can't they be given an opportunity to opt out for a given period of time and then be back on the list again, or opt out completely so they can't? And also, do we really monitor what Delmarva tells those people? Because Delmarva is sort of a competitor here, right? So they don't necessarily have the incentive to be real rigorous with respect to their explanation to the consumer about what rights they might be giving up, what opportunities they might be giving up. Seriously, do you know what they do?
To that.
Yeah, I don't believe that Delmarva is a competitor.
Well, I mean,
we've never considered ourselves a competitor to third-party suppliers.
Well, I'm just speaking generally speaking. I assume that if they're going to take over electric supply, there's a little less electric supply that Delmarva is going to be distributing.
We don't, Chairman Winslow, we don't view that as a competitive issue for us. We continue to provide. There are still distribution customers. We continue to provide services to them as we have in the past. We have said since the Choice docket opened some time ago, which is a companion to this, that we support Choice wholeheartedly with some minor changes to what Reese is proposing. So we have always supported Choice. We will continue to support Choice. We want what's best for the customer. In fact, I think you may recall that as part of the direct energy petition that you just went through not too long ago, there will be, in probably December's bill, there will be an insert about Choice again, specifically talking about the options that are out there and the suppliers that are active in the marketplace. So, with all due respect, we are not competitors to electric suppliers.
Okay. No, I accept that. But I mean, I guess I have a little bit of a concern about how much knowledge that individual consumer has, what sort of position they are in to make a decision on that, and how thorough, their opt-out is, how knowledgeable it is. I guess that's my general concern, Ms. Loper. Can you respond to that for me, please?
I hear from customers all the time calling into the Commission and inquiring about our list. So I think that they do have the opportunity to shop if they so choose. But that's on them to decide, not for the supplier to just say, "Oh, well, you didn't opt out of the list, and now you're on the list, and we're going to market to you actively." I think there's two different issues there. That the customer has said, "We don't want telemarketers coming or door-to-door marketers coming and soliciting," but to take away the decision to choose altogether, they have marketers come to them, I think is not going to be looked upon well.
I think I also asked whether or not there could be two choices. One would be forever and ever, and one could be for a year. Consumer would have the opportunity to opt out for a year, maybe to think about all the different choices, not get bombarded by telemarketers, and yet, after a year has passed by, start receiving those offers again.
Mr. Chair.
Ms. Conaway?
If the information is available on Delmarva's website and on our website, then the customer who opts out in the beginning has the opportunity, whenever they so choose, to take the responsibility for their own choice and go in and find the information.
Ms. Scott, I have a question. And are really 36% have opted out of customers?
36%.
I think that's roughly right.
Of residential customers, yes.
So how many of that 36 to 37% opted out in 2006, and what percentage opts out of new customers opt out today?
I would have to get back to you about that. I don't have that readily available.
I'm just wondering if a lot of people opted out 10 years ago when there was a lot less information available, and that you would not necessarily want to stay opted out, but you're saying you would want to stay as an opt-out. But I'm just wondering if this is something that happened a long time ago where there could be like another question, but or do 37% of new clients also opt out?
Mr. Chair, ma'am.
Mr. Gray?
So I think as I'm listening to this conversation, I've signed up for the do not call list, and then when I get called, I get pretty angry. So there must be in some way, though, a balance that allows the marketplace to reach customers. And I think the chair has been asking this question, but what about a balance of 3 to 5 years out? The customer is asked again. I don't think it makes sense every year. I think that's too frequent insofar as trying to determine whether someone wants to opt in or out. But can someone tell me what opt-in means? Does that mean that you open the gates to anyone who wants to market that customer, and there could be 10, 12, 15 providers now approaching that customer?
Yes, that means you're on the customer list. Whatever supplier obtains the list, your name is on it. They can reach out to you and market to you. I'd also like to point out that of the PHI jurisdictions, Delaware is the only one that has a customer list requirement. We do not do this in our other jurisdictions.
What does that mean? Sorry.
That means we're the only utility in the PHI, Maryland, D.C., New Jersey, that actually makes this information available to electric suppliers so that they can market to customers. Otherwise, I assume what they're doing is they're buying lists or getting information in another way.
And can I move the discussion to the information list, because I think that was another.
Will you finish up with Mr.
Sorry,
Geddes,
okay.
please?
Sorry, go ahead.
If I might, on the information list, I'll be brief, as Ms. Loper has asked me to be. We agree with Delmarva. However, there is one other issue, and that's rescission, and I can address it now. I'll address it later since you want me to address it now. The rescission issue, obviously, Mr. Green talked about the concerns about the difference between 3 and 3 and the 7-day. My calculation is that that's 4 days, and it takes us a step further in terms of shortening the rescission period. I disagree with, and he didn't use it in his comments, and I thought it was a brilliant term, Amazon time. And also he did cite.
I was reading Ms. Iori's brief, and I looked, and it was Brian Green.
He did refer to the checking, and he did refer to the food. And I would suggest to you that in each one of those cases, you can reverse that. Certainly Amazon, whatever you get in 2 days, you can send back immediately, and they send you post-it, and they're very good about it. I'm not sure about perishable food, but I assume you could say I'm not paying for it. And then third, of course, if you do make a mistake in doing your transfers, presumably unless you transfer it to a third party, you can recover the transfer or put it in the right case. I'm sure Commissioner Drexler can tell us about that. But the point is, this is not quite the same, because some of these contracts have penalties. And so if they miss the rescission date, they're on the hook for whatever the contract says in terms of termination. Now, maybe they would give that a waiver, but clearly the customer might be at risk. And I would remind you, as Ms. Loper did in the comments, that under the Delaware telemarketing rules, it's 7 days. And under the Commission's prior decision, although 10 years ago, you were confronted with a 3-day rescission period, and you disagreed with the 3-day rescission period, saying that you would not accept it because it's not sufficient to provide a potential new customer with knowledge of his or her right to rescind prior to the extinguishment of the right itself. That is the order 7023, which I believe Ms. Scott referred to. So here we are 10 years later, and we're not asking for a 10-day rescission period, which is what was being considered there. We are saying, yes, it should be a shorter period. It should be 7 days, but it shouldn't be 3 days. And so the Commission, as a policy, you've heard Mr. Green's arguments, and obviously this was a compromise. I mean, clearly RISA and the DPA took the lead, but Delmarva and staff were also part of the process at the end. And any type of settlement is a compromise of positions. In fact, staff would suggest to you that some of its positions, such as variable pricing and introductory pricing, would perhaps be more expansive for suppliers than what has been agreed to. But we agreed to these rules with the exception of this rescission and the customer list, and we believe that the rescission period of 7 days is appropriate. It's a 4-day difference, but there are certainly risks that are associated with some of these contracts that if a customer misses that period, they'll be responsible for, and that's why we think 7 days is appropriate. Thank you.
Thank you, Mr. Ignatz.
Your Honor, before Commissioner Gray moves on to you were moving on, I think you're about to move on to a different area of customer lists and move away from the opt-in, opt-out discussion. And before,
I think that's what he intends to do, but
right.
the other commissioners may have something else. We've all had something to say here. Now, Mr. Houghton reminded me we actually have a hearing here. Is any of the parties going to submit any further evidence besides what's been briefed?
The DPA is not.
It's really up to the Commission. There are comments that could be made as part of the record or not. And that's really up to you. I don't believe any party was going to submit a witness to say these are my comments.
That was my impression. Mr. Green, I'm sorry. I'm not sure what you wanted to say, but I'm more concerned about what Commissioner Gray wanted to say, so I'm going to ask Commissioner Gray to ask this question.
Thank you, Mr. Chair. With respect to the volume of information that I believe you mentioned was still an open issue, yes? Okay. My understanding is most of that information is going to be used for the purpose of marketing to customers, and it's going to be derived as a source from Delmarva. Is that correct?
Under 3.3.3, it can only be used for marketing and for providing electric supply service to the customer. So yes, is your answer. Yes, and it's in the rule that is
so. I'm looking at this list in terms of data sets, and they seem to be quite numerous, and the idea that they're updated monthly seems to be significantly frequent. And I've heard Ms. Scott address the fact that the full scope of this information should not necessarily be provided as it appears in this revised text. Why should the marketing company benefit from all of the information, let's say in this H through Q, wouldn't it be reasonable to expect that a company selling something to a customer would be able to derive more information from the customer as they build that relationship? So in other words, I'm a company, I have something to sell. I'm asking, wouldn't I get information from the prospect and the customer as opposed to expecting someone to hand me everything on a tray that I can use to be ultimately successful with my customer?
I don't know what third party you might get this information from that would have the information. Only, if that's your question, only Delmarva is going to have most, if not all, of this information that would be in the customer list.
Okay, so if Delmarva, is there a cost to assembling this information? I'm asking now Delmarva. Okay,
Yes.
and who bears that cost ultimately?
Ultimately, the ratepayers would.
Okay.
Well, may I interject there, Commissioner Gray? Or is there some new item that you would have to collect that you don't already now collect on that list? Because if you have to collect it already, obviously you're already collecting it, and you already incurred the expense, and there's no additional expense you're going to incur.
So currently on the customer list, we follow the letter order: customer name, mailing address, service address, rate schedule, bill cycle, and whether or not they participate in a dual bill. The additional items would be account number, which to us is tells us that the customer has consented to all of this information, and then any usage and peak load history. All of that information is already provided in a pre-enrollment transaction. Once the supplier has the account number, they can actually send in a transaction and get all of the information that they're asking for on the marketing list. So the marketing list right now, in providing the customer name, mailing address, service address, rate schedule, and bill cycle, can be used for just that, marketing and winning that the customer's consent to get the pre-enrollment information.
So if the customer shows up at the kiosk and doesn't have his service number, or doesn't have his account number, yet wants to get signed up for service, the kiosk guy can just call you, and not you, but you, and then pass the phone over to the customer, and the customer would say, release the information, you release it?
Well, they can get their account number, and once they have their account number, or if they're on my account and they already have an established login ID and password, they can get the account number that way. They can then give that account number to the supplier, and the supplier can send in a pre-enrollment transaction where they would get all of this historical usage information, 12 months of history.
Thank you.
So it's a question of timing more than whether they have it as a...
It's consent, really. I mean, the marketing list is if you are an active supplier in Delaware, whether you serve any customers or not, but you're licensed, you can go onto our website and pull off everyone who's opted into this marketing list, pull their service information, their service address, their name, that kind of thing. Once you actually win their business, you typically get their 22-digit account number, which is on the third page of the bill. And the supplier has that and can send in an enrollment transaction, a pre-enrollment transaction, and get all of this other information that they'd like to have, like what the customer's peak load contribution is, what their 12 months of usage history is. And if it's an interval request, it's in 15-minute increments for the 12 months. I don't know how we would put all of that logistically onto an Excel spreadsheet.
So one question. Can you tell me, therefore, how the absence of this additional information is going to hinder the marketing and the acquisition of customers by these suppliers? How is the absence of that? That's for Delmarva. How is the absence of this additional information going to hinder their efforts to get customers?
I can't see that it would hinder the suppliers, except that they, instead of just getting it on a platter, they have to go and send a enrollment transaction in, which is what they do today.
Mr. Green, could you respond to that, please?
So the usage information, as I said earlier, is a key component of what's on the list. In order to get the pre-enrollment information, which I think is section 3.2 that we've added, you have to already, the way Delmarva interprets the rule, you have to already have the account number. So you have the account number, and then through EDI, you get other data points that include the account number. Ideally, you shouldn't have to have the account number, right? I mean, because you're getting the customer's consent to get pre-enrollment information that includes the account number. But what you don't have at a kiosk, in your example, is the service number. The 22-digit service. Getting the customer's current account number, even if you memorize your account number that's on your bill that you got this week or whenever you got it, is not going to get you enrolled with an electric supplier because you have to have your 22-digit service number. So it's an extra step that all suppliers have to go through to get that number in order to enroll you so that you can take advantage of whatever product it is that you want to enroll in. So all of this is being done to help create an easy way for customers to make a switch. And when there are these barriers such as 22-digit numbers and lack of usage information where suppliers cannot design new products and target specific customers or geographic areas or whatever the case may be, it's a real disincentive for suppliers to come to the market. And that's all we're trying to overcome. These data elements, with the exception of one or two of them, come right from what has been in place in Pennsylvania now for 5 or 7 years for electricity and natural gas, over 6 million customers. And there's never been a problem. So all we did was include in 3.2.1, in addition to the account number, any other number designated by the EDC as necessary to process an enrollment, which is the 22-digit service number. And then what jumps out at me is 3.3.2.15, the dynamic pricing election, if any. Most, if not all, of the others come right out of what's been in place in Pennsylvania. We did our best not to make this part up, right? Because we know that it's tried and true and it's working for 6 million other customers. And there's no reason why Delaware is any different. So with respect to the importance of the usage information, I just wanted to try to paint that picture of how difficult it can be to enroll a PHI customer because of the 22-digit service number. And in having usage information. And on a day-to-day, once you have that customer, I just want to point out, PHI does a very good job allowing suppliers access to smart meter data on a next-day basis. You can log in, you get it all in a batch file for your own customers, not for other customers, for your own customers. So they actually, of all the suppliers, of all the utilities in the Mid-Atlantic area, they do it better than anybody. So that's the response to the importance of usage information. Is that it is really a tried and true method and reason why we want this information. If we didn't think it was necessary, and this is one thing that sets me back a little bit, like when other stakeholders that aren't suppliers say suppliers don't need that information to market. If it wasn't important, we wouldn't be lobbying for it. We wouldn't be asking for it. There are other things that are way more important we would have tried to get in this proceeding than customer lists if customer lists weren't that important. They are very important.
Okay, well, the reason I started, and Commissioner Gray, I'm assuming, the other commissioners think this is important is because I have a little bit of disconnect here because what I'm hearing from Delmarva is that if you're at the kiosk with the retail supplier representative and somebody wants to sign up for a retail supplier and service, you call Delmarva and the customer gives permission to Delmarva and gets the number. You write it down on your pre-enrollment sheet and then you get the data that you want to get. The only extra step you have is the customer making the phone call, which adds to the validity and the increased privacy, et cetera. Now, I know it's an extra step and an extra burden, but it doesn't seem like it's anything insurmountable. Plus, I assume that if you get someone's historical data, it's got to take some while to fashion an appropriate vehicle.
Right. The ability to access that information at a kiosk or a mall is not necessarily the usage information because you already I would think the supplier already has the product that it's trying to sell you, right? What they need it for at the kiosk or the mall is to get the service number so they can enroll you right there. right, and start that rescission process going. You can't do, I don't think you can do it right there because you don't have the information that you need. Right, if you don't have the customer's account number or their service number when you are interfacing with the customer, you're not going to get it. There's no way.
Ms. Scott, would you swear have your witness sworn in and testify on this issue, please?
Full name? Natalia Mathura, Natalia, last name M as in Mary, Athura.
You swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you've heard the discussion between commissioners and council with respect to how an individual can sign up for alternate retail supply. And the issue, I guess, is that we have a customer at the kiosk. Customer obviously doesn't have, like Mr. Geddes right now could not tell you his service number. He could not tell you his account number. He couldn't tell you even how much he gets in the bill each month. So that's the person that shows up, and he's like me. I don't know. I don't pay that bill. My wife does. So, I mean, so I show up at the kiosk, and I'm excited about this alternative supplier and the program that she I said, sign me up. And so the guy or the gal at the kiosk, it's a Saturday, right? Can they call Delmarva on a Saturday?
They could.
And can they reach somebody who could provide the service number and the customer account number to the kiosk guy or girl?
My understanding is during the hours of customer service, and I'm not exactly sure what the start and stop times are, but they could call and get their 22-digit service ID. And they can also get it through my account.
Okay. So, and of course, through my account, if the kiosk person has a computer, then they can use that person's computer to look up their own information on my account. Correct? So they could actually, the kiosk person could lead the customer onto the computer and actually lead them to my account and get that information without even calling Delmarva Power Line.
Correct, but the customer would have had to establish the my account to begin with at some point. If they had their account number with them, they could establish it right then and there, but then they wouldn't need to.
Yeah.
Thank you. Any questions?
One last question. Ms. Scott, that 21-digit service number, is it implicitly on this list of your items A through Q? And can you point to it? Is that the customer account number, item H?
Yes.
Okay. Thank you.
Yes, sir.
And just to be clear, Commissioner Gray, the 22-digit number is part of the SAP process. We're not the only utility that has that, but as part of the SAP process, there's additional numbers added onto the account number.
Okay. Thank you.
Mr. Green, do you have any questions of the witness?
No, are you sure that the Delmarva Customer Service Center is open on Saturdays and Sundays?
I believe it is. We can have someone check.
Could you do that, please? Because I don't mean to. I think we just want to get the information right. If it is, it is, and if it isn't, it isn't. When you Google it, it doesn't say they have weekend hours. So I just want to get the facts right.
Before you go, does anyone else have a question of the witness?
You have to be excused. No, I have no questions. Thank you.
So if I just play this out and make sure I understand.
Yes, please.
So if I am at a mall and I walk up to a supplier's kiosk and I don't have my account number, I don't have my service number, I have not done my an account online with Delmarva, and I want to sign up, how does the supplier find the information that it needs in order to enroll the customer at that point in time?
So the only way is the way that we've just talked about is you already have a My Account and you can go online and check what your service account ID is, or you can call. And I have to figure out exactly what the hours are. Obviously, if it's outside the hours, then you can't.
And if I call, what information do I need to give the customer service rep so that they will give out my account number to me?
You just need to prove that you're the principal account holder.
How do I prove that? Is there a PIN number? Is there a...
There's no PIN number to my knowledge. Unless that's changed recently, there's no PIN number.
So anyone could make that call then? There's no, what security do you have that you're giving out that private information that someone could just make the call?
It's the address. They verify the address.
Okay, which can be found in the telephone book or as public information, right? Okay, so for the same kind of concerns that you think suppliers are going to have to mishandle the list, anyone could have the same kind of concerns about Delmarva giving out account numbers to callers. Is that right?
I don't think she's been settled on as an expert with respect to what information they ask for before they release the confidential information to some third party. It's probably more extensive than what she's testified to. I don't know we can, with this witness, that we can go that far.
Can I ask a question of
Ms.
Mr.
Scott?
Green?
Sure.
I guess the question is, why can't the person at the kiosk give the potential customer a card and say, go home, get your account number, call in, we can proceed through the process at that point? I mean, are you going to lose the customer because they have to do that? I mean, if they're interested in the process or the product that you're offering or the service that's being offered by the supplier, I don't understand why that's so difficult.
All I can say to that is that my clients cannot underscore enough the importance of being able to engage a customer outside of the home, outside of a phone call or a door-to-door sale, and be able to market to that customer and sign them up at that point in time and make for a very seamless shopping experience. That's the goal of just like you could walk into the store and buy anything you want and walk out. You don't have to get a card and go home and order it online or call the retailer. So you ought to be able to make that transaction at that point in time, and just like you can do any other product. That's the goal. And without having to jump through hoops and go through 2 and 3 and 4 steps in order to enroll that customer.
Mr. Geddes, did you finish with your comments, opening comments?
I did. I addressed the 2 issues. Well, actually, there's A and B on the customer list, and then the rescission. So thank you very much. I did.
Ms. Iori, did Mr. Geddes inspire you to make any further comments?
Be careful.
No, Chair Winslow, thank you.
Mr. Green?
I do want to just say a couple of brief points to things that I heard earlier. Staff acknowledged or pointed to the status quo of opt-in versus opt-out. You shouldn't upset the status quo. But the status quo is not working. There's 10% shopping in Delaware. There's very few suppliers marketing to mass market customers. And we're doing a lot of things at the Commission to try to change that, and this is one of them. Information is key, just like in everything else. And having customers know that you can market to is key. And being able to find them, being able to design products specifically for them, and being able to enroll them smoothly is all very important to the entire process. The other thing is there was back and forth about why is it not okay to get annual notices to remind them. I would only point out that in 3.3.1.1 spells out exactly what should be in that annual notice, that what the customer list is, what the information is that's on the list, and other 5 more elements. We have provided in the last couple weeks the stakeholders with sample letters from Pennsylvania, from one electric utility and one gas utility of what that letter looks like, what it has to say. That's gone through the Office of Competitive Market Oversight. They've looked at it. They thought it was fine. Of course, Delmarva can get a similar letter from their own affiliate, PECO, which serves electricity and natural gas customers in Pennsylvania, and has been doing this for several years now for its customers. So I would remind the Commission that this is an issue. These are all arguments. If you work through the Pennsylvania orders and other orders from other states, these are not new arguments. They may be new to Delaware, but they're not new in the overall scheme of market structuring and so forth, and the value of customer lists to suppliers. And then finally, and in places like Pennsylvania have held that it's okay to give periodic reminders. It's good for customers to give them periodic reminders that there's a market out there, and they can opt in to getting more information about that market. And then finally, Ms. Scott referenced that of the 5 different utility footprints that Delaware is the only one that has lists. That may be true, but 2 of those utilities are in Maryland, and they've never asked, to my knowledge, the Maryland Commission to have lists. That may be coming up. Someone else may force that issue in the future, but Maryland has allowed BGE to have opt-out lists. D.C. has a special statute, so it's really beyond the Commission's control there in D.C. So it's not condensed the narrative a little bit on what the PHI footprint looks like in terms of customer lists. That's all. And then on the rescission period, I would only underscore again the 2006 decision with respect to the rescission period. The market has changed, and but apparently not for Delaware, right? Because we only have 10% and very few suppliers. So the PSC can change its mind. If it did in 2006, thought and that was a 10-day rescission period based on when the utility sent the letter out to the customer. So it was a much longer rescission period, and now we're getting that down to where customers can take advantage quickly of what they want, and then if they don't like it, they can get out, or if they don't like the price coming up, they can get out quickly. So I would remind everyone as well that if you have a variable rate and you have a 12-day notice rule, 12 calendar days, with a 7 business day rescission, that's going to impact for at least a couple days whether that new rate becomes effective that you're trying to get out of. So again, that will impact it. So you want that rescission period. We're not asking for something that's smaller than unheard of that hasn't been in effect somewhere else. Right? Pennsylvania's doing this. D.C. went from a 10-day down to a 3-day several years ago, 2009, I think, and there have been no problems. So what I don't want the Commission to do is fear or make up problems that don't exist. If there is a problem down the road, I think we can revisit it, but there's no reason that staff has presented in favor of a 7 business day rescission period that ought to be valid today.
Ms. Iori, so the record's clear, the public advocate agrees with Mr. Green on these 2 issues?
Yes.
Just point of.
And I understand that Mr. Goes is part of their compromise with settlement.
No, but it's our issue, so can I just have 2 sentences?
Certainly.
On the first point, about the customer list, these are not reminders. It's not sending a notice. What Mr. Green wants is basically to change everyone who's opted out to an opt-in. So that's not a reminder. Clarification point. And second, as you well know, the Commission obviously on a policy issue can change its mind, but I'm not sure that Mr. Green and his attempts to convince you that this particular rescission period that staff is shortening down to 7 days, that the circumstances, what the specific circumstances are that have changed since the last time you revisited this. It's clearly there are more suppliers. There's more information. We've discussed all that. But you made a decision then, and I think if you decide that a shorter period like 3 days is appropriate, you should indicate on the record why.
Well, I think Mr. Green indicated that there's only 10% utilizing the alternative suppliers. You would argue, I think, that that's a reason why some change has to be made. And 36% of the people have opted out, and they can't be marketed to directly, I guess, through the method they want to do it. It's been successful in Pennsylvania, highly successful. As a matter of fact, Pennsylvania appears to be the gold standard. And it's got a 3-day period. It's got the lists, and they have a robust retail supply. And of course, that's Pennsylvania. That's not us. It's 6 million people.
Point of clarification, as Ms. Scott stated in her comments, their regulatory system is much more robust as well. So in essence, they've taken chances with marketing and suppliers that perhaps other states would not have taken just because they have the regulatory oversight.
Thank you for reminding me of that. She did say that in her brief, and I would like to know from Ms. Loper, what is the difference? I mean, if we start getting a lot of complaints from consumers about the customer list or the rescission period, is that going to create some big burden on staff that I'm not knowledgeable of?
I can't say that it will or it won't. I don't know exactly how it'll impact staff.
Ms. Ivory?
Thank you, Chair Winslow. Actually, the rules specifically provide that if a customer, and this will be something that goes into the contract or the contract summary, if the customer does have a complaint, there's a procedure for as to who it goes to. At first, this is section 10.7. The customer should first notify the electric supplier, and if they're not able to come to a resolution, then they will contact the DPA with its complaint. So it shouldn't have much of an effect on staff. It will have more of an effect on the DPA.
Thank you, Ms. Ivory. Any commissioners have any more questions?
Yes. I have one question.
Mr. Correa?
Mr. Green, this question may be a little bit odd, so please excuse me. And if it's not related, you can say no, and I'll accept it with a smile. Last 6 months, if you walked in the mall, how many times you signed up right away at the kiosk for telephone, for the water bottle? How many times people sign up in 1 second of marketing brochure?
Are you asking how often it happens?
It didn't happen to you personally. It has not happened to me for 10 years.
So a couple things. I'm the wrong person to ask because I live in Virginia. So when I go to the mall, you just see big Dominion Virginia Power signs and how wonderful they are. You don't see third-party suppliers because there's very little opportunity for residential customers to shop.
Right.
I can tell you that I have clients right now in Pennsylvania that have tables or little sections within or just outside of Walmart, for example. I have clients that have kiosks in malls in Pennsylvania, and they do this. And it's one reason that they like it is because it's not door-to-door, right? It's not telemarketing. And I briefed this, typically consumer advocates, if you ask them to rank which marketing channels they like the best, I can pretty much guarantee you that door-to-door is going to be somewhere near the last and maybe only right there with telemarketing, right? Because that's a supplier door-to-door coming to your home, right? And this way, away from your home, the customer controls when to engage or disengage with the supplier. So it's a much more beneficial many suppliers favor it more so than door-to-door and telemarketing as well as the customers do. But I can only answer that question by saying I have clients that do the big box retail, the kiosks, and look for other ways outside of the customer's home to engage with customers.
Okay. Thank you.
Ms. Scott?
Thank you, Chair Winslow. I just wanted to make some follow-up comments on a couple of things that were said. And I appreciate that Mr. Green continues to refer to what's going on in Pennsylvania. And as you indicated, I think we all can agree Pennsylvania is the gold standard. But they have an Office of Competitive Market Oversight that oversees all of this. They have a very substantial website for electric suppliers, all a number of things that we do not have here in Delaware. And while we may get to some place or some point where we're closer to the Pennsylvania example, I think it will be a long time before we get to where Pennsylvania is. But having said that, we are working very hard to implement choice in Delaware. And Delmarva, as I said many times today, is a very large proponent of doing that. We don't have kiosks in Delaware for electric suppliers. That's something that if the rules change and everything goes the way Risa would like it to go, then it's probably something you will see there. In terms of changing how the opt-out process works, the only thing I would say at this point is to the extent that the Commission wants to change it to something along the lines of what Risa would like to do, there will be a cost associated with doing that, and we need to determine who's going to pay for the costs of doing that. I don't think it should be Delmarva or Delmarva's ratepayers because it's something that's benefiting the suppliers. But I wanted to put that on the table so that the Commission could have the opportunity to consider that. Thank you.
Thank you, Ms. Scott.
Mr. Chair, one.
Commissioner Gray.
So, as I'm listening to the conversation, the thing I think that worries me the most is if every year the customer has to opt out again. I think that the suppliers need to think about the mindset that's going to place on the prospective customer, not to mention what Delmarva's concerned about, but the mindset that's going to place on the prospective customer, that every year I thought I remember opting out. I think the better compromise would be either every 3 years you send them a notice that says, important, opt out again, or you'll be marketed, right? But I think every year is way too frequent.
If I may respond to that, Your Honor. Pennsylvania is 3 years. They have what they call triennial refreshers. So every 3 years, the utilities send their customers a notice that they can opt out for another 3 years. In our discussions, the RISA DPA discussions, we had agreed to 1 year. I can't speak for DPA. RISA is not anti 3 years. We could live with that. We're living with it in Pennsylvania, and it's working well.
My problem on this whole thing is that the General Assembly has basically said that it approves of retail alternative suppliers, competitive marketplace, and we haven't done as well as, in my opinion, we haven't done as well as we could have in that area. I'm very, very happy with what has transpired today. I want to congratulate the parties because you really did from, I guess, a month ago, wherever it was. There's been a lot of movement, and I commend you all for what you've done. I think I heard what Commissioner Conaway says. You know, customers got to take a certain amount of responsibility, but customers are merely people, and you know, if you let them opt out, and then they don't hear anything about the competitive marketplace, they might not even know about it or have the opportunity. So I think that giving them the opportunity at some point in time, like Commissioner Gray has suggested, makes some sense because that person who wanted to opt out might likely, a fair percentage of them might want to change their mind after seeing what's going on in the marketplace and seeing what the marketplace has to offer. So I think I sort of lend to that. With respect to the customer information, I just don't feel comfortable going along with what RISA and DPA want with respect to the customer list. Actually, to be honest with you, let me tell the truth. I feel comfortable. I just don't know that the record is such that we can go that far at this time. And what I'd like to see is have some provision where we review the customer list and the opt-out provisions at some time in the future so that we look at some data and see what impact these actions we're taking today have on the marketplace, would be positive or negative, and we have a chance ourselves to not opt out forever and ever, but to look at this issue, I don't know, 2 years from now, whatever it might be. And I assume that Pennsylvania and District of Columbia, not Pennsylvania, but Maryland, these other jurisdictions are going to be looking at this issue, I'm sure, in the near future. So I'd like to have a provision in the order that would permit us to rethink these two issues after we get some more data and maybe have some more impact. Because right now I have no idea what the expense that Delmarva was talking about would be. That's the first I heard about I guess there maybe was some passing mention of it in a brief, but I have no idea what that's all about, to be frank with you. So anyway, that's me rambling on. I apologize for rambling, but I do feel strongly that we really should work toward that gold standard in Pennsylvania. And it'd be nice to see people be able to get signed up and get an attractive bargain in the marketplace. I'm amazed, you know, I get a message on my phone, and it says, "Dear Mr. Winslow, your wife has once again ordered something from Amazon. It will be arriving at 3:45 p.m. on Thursday." Wow. And it says, "You want to change your delivery date or your delivery time?" And there's other options. And customers and consumers are just have a mindset where if they need to accomplish something with respect to their personal needs, they have the expectation they can do it immediately or almost immediately. And I understand what Ms. Loper is talking about people calling up and complaining and whatever. But you know what? These electric suppliers have come through here, and staff has determined that they have the management skill, the operational skill, the financial wherewithal to operate in this state as competitive suppliers. I have no problem with giving them every bit of credence with respect to the privacy of our consumers' information as I do DP&L. I don't see them with any difference whatsoever. So, it's not a matter, as far as I'm concerned, with respect to trust. I think we've already reposed our trust in the retail suppliers. And if there are problems, as Ms. Iori has pointed out, there's ways to resolve those issues or problems that come up. So I guess what I'm saying, trying to persuade some of my fellow commissioners to maybe support me on this, even though they didn't support me on my $500,000 for my electric charging stations. But, oh, okay. That I'd like to, I'm inclined to vote in favor of the 3-year opt-out situation with a renewal after 3 years, like Pennsylvania does apparently, and not agree to the customer list at this time, but to revisit this issue at some point in time, let's say 18 months from now when I'm probably retired and Mr. Howitt's probably retired. And but we do need to, I think, revisit this and see what the marketplace is doing. Are we really encouraging people to do electric supply alternatives or not? Are we really being successful with respect to what the legislature has wanted us to do? I think we need to revisit it. And maybe no one else feels that way, but I do. Commissioner Conway.
I would support both the no additional customer information and the 3-year opt-out. I think we have one more issue, and in that the rescission, the 7-day or 3-day, and I would support a 7-day rate of rescission.
Commissioner Drexler.
I would support a 3-day rescission. And I think the opt-out is opt-out, and I think, we're going to revisit, and I think revisiting this in 90 days or, 4 months is important because that piece is going into the Delmarva bill in December. I don't know if that'll generate a lot of interest with the alternative providers, but it could, and I think we can look at it from that standpoint with more information. But I think, like Tony said, opt-out is opt-out, and I think people would be more upset having been opted back in when they thought they were opted out. So that's where I stand.
Make a motion.
Mr. Howard.
Chairman Winslow, as probably one of the few non-lawyers in the room, I would like to ask a procedural question. It seems to me that the previous order that published these regulations allowed for comment through November 15th or something like that. Would you be making a decision today, and shall we just throw the comments we get at that point into the waste can, or will you be delaying any decision on this matter at this point? I'm just not sure how procedurally we get into this conundrum with that, and maybe Ms. Iori has a better feel for where we have to go with that.
Well, there are being some substantial changes, or some changes of substance will be being made to these rules, so they're going to have to be republished anyway. So we are essentially going to go through all of this again in another month or so. Hopefully not, the commission will have indicated what it wants, and those are the rules that will be published. So there will be another comment period for those rules, and then the commission can choose. I mean, as the Register of Regulations told me when I asked about this silliness, they said, as long as you leave it open for 15 days after the record is, or after the commission has its meeting, you don't have to do anything with those comments.
Okay, thank you.
Well,
Mr. Geddes.
Point of clarification and following up on this, it really is up to the commission. I think the way that the register intended in the statute is that if you made a decision today, then there would have to be 15 days for additional comments, and those comments would come back. No, That's not right?
That is not right.
What, they don't have to make a decision today?
No, they can make a decision today, but they don't have to wait for additional comments to come in. It was not, that 15 days is not based on them making a decision today and having a chance for additional comments.
Well,
that's the way the statute is written. They could have had this meeting a month ago.
my only point was I was trying to give you a way to allow the parties to perhaps parse these two issues a little bit more and perhaps come back with a compromise on one or two of the three. But I stand corrected, and I will withdraw those comments.
Well, and just as Commission Counsel, there's a suggestion that the Commission might revisit this in 2 years, or this is a regulation docket. So the business that we're about today is to adopt what I thought was a final regulation after a 4-year process. Certainly is within the Commission's power to then reopen any of its regulations at any time, but then to do that would be kicking off this process again if it ever winds up at any point. So certainly the Commission can reconsider this at any point in the future, but depending on how this docket is resolved, it might mean opening another regulation docket and considering further amendments outside of this 15-day issue.
Mr. Chairman. So I think what I've heard in terms of the open issues, opt-in or opt-out, clearly opt-out seems for me, from what I've heard, the appropriate stance to take. With respect to rescission, my view is that we want some balance to try and get this marketing successfully within the state of Delaware. I'd say 3-day rescission is acceptable in my view. With respect to the customer information, I think I agree with the chair, and that is the more limited amount of information in Mrs. Scott A through G. Although there's a question in my mind about the customer account number, whether that should be included, but clearly not the rest. And one last point that I didn't hear discussed, although it was discussed in different ways by Mr. Green and Mrs. Scott. Ms. Scott and Marva are refreshing the customer list twice a year, and the expectational recommendation for Mr. Green is every month. And so it's not clear for me which of the two of those is the path forward, but my inclination would be right now to go with the standard twice a year that Delmarva is currently doing, but I don't know the impacts on you.
On that issue, the only discussion I've had with my client is that we would be okay with quarterly updates of the information that's on the list, if that's helpful. I didn't, you rule how you want to rule, but if we would move off of monthly, we've had that discussion with the parties, and generally I think that was either okay or the party didn't care. So it was 1 and 2, depending on who you asked. So hard to react accordingly.
I'm sorry, Commissioner. We had proposed that previously. We're fine with quarterly.
Delmarva is okay with quarterly. Okay. Thank you. No further comments.
Thank you, Commissioner Gray. Well, speaking to Commissioner Drexler, I understand your position on the opt-out situation. If you opt out, you opt out forever. But I just think that doesn't take into consideration human nature and the fact that there's a changing marketplace, and that we need to inform the customers of what's going on in the marketplace, and allowing them to opt out forever and ever, I don't think is going to support marketplace. It 1,000% supports the consumer. I understand that, but I don't see any great harm in advising the consumer of his or her ability to opt into retail energy supply contracts every 3 years. It doesn't seem to be a huge burden on consumers. And in fact, they probably won't even remember that they opted out when they get the marketing piece. Some will, and they'll call Tony. But that's my thinking on that particular situation. And plus, I think hopefully it'll help move some of the numbers because it'll be allowed more people to be marketed to. Maybe we'll move the numbers to the competitive marketplace a little bit better than we have so far. And also my thinking on it is it's been a long day and sort of complicated, and we've all come down sort of in between each other. So I guess my suggestion to the commission is that why don't we think on this and come back and make a decision on November 15th. And then Mr. Geddes and the parties, if they want to, can talk some more. We can think about it, and we won't communicate about it. Ms. Iori, is there a procedural problem?
Yeah, she believes I'm incorrect on that.
No, I think Mr. Geddes is incorrect on that, but there's also a more, because we're going to have to republish these regulations again. If you make a decision today, we can get it ready so that it can go in the December Register of Regulations. If you come back on the 15th and don't make a decision until then, we will not be able to get it published again until January.
Commissioner Conway.
I'd like to make a stab at a motion, and I will need legal assistance, please. I would move that we adopt Order 8974 with the following provisions. All right, why? Oh, I'm in the wrong one. I'm sorry. All right. What I would like to see is 6-month update as it is, April and October. 3-day right of rescission. No additional customer information. And the 3-year opt-out alternative, so that the customer has the opportunity in 3 years to, and they have the opportunity daily to opt in if they so choose. But that the opt-out list come up every 3 years.
So just to clarify that every 3 years, the customer would have to renew their
Opt-out, yes, yes.
And one, might I add, Commissioner Conway, that the customer list is agreed to be updated quarterly.
I had said 6 months, update the customer list.
Oh, I'm sorry.
In April and October as it is presently.
I wasn't sure.
Yeah. They were the 4 things that.
And then, Commissioner, I would add that your motion would include the consensus of the parties as presented today.
All right, that's what, I wasn't sure how to put that in it.
The clarification of these 4 disputed issues.
So moved.
Commissioner Drexler?
Quick question.
Point of order, Mr. Chair, before you can have additional discussion, Chairman, we need a second.
Yeah.
Will you do me
You have to
second the motion, then make your comment?
Oh, I second the motion and I have a comment. With the opt-out, when a client calls Delmarva today for new service and they select opt-out, is the language in that opt-out, is that a written opt-out, a verbal opt-out, and does the language say you will never be solicited or you're opting out forever? Is that going to be a situation where we're kind of lying? If you say you'll never be contacted and then we change it.
I don't think the commission ever approved any language that was being used by Delmarva Power and Light on that particular.
There's no script that I'm aware of, and obviously suppliers, in many states, when a utility is asked to explain something choice related to the customer, there's a script. Suppliers get to review it and trust that the utility is implementing it. But we don't have that here, and we don't know what they're saying to the customers.
I have a copy of what we used when we initiated this process after you had approved the changes back in the end of 2006. So what it basically says is the title is Privacy Notice, It's Your Choice. Delmarva Power's electric customers are able to choose an alternative electric supplier at any time. To help develop a competitive market, Delmarva Power is required by the Public Service Commission to make customer name and address information available on a marketing list that is available to alternate electricity suppliers. If you do not want Delmarva Power to share your name and address with alternative electric suppliers, you must remove your account from the marketing list, and we give a date. And then we tell them, if you want to remove your account from the list, contact us via email or by calling a certain number. And then there's a second page that basically talks about choice and making an educated choice about your supplier. I don't know if you'd like to have this.
The court reporter will.
So my only comment, if I may, on that is that if you look at the elements in 3.3.1.1, which are the required provisions in the Pennsylvania notices, that script doesn't say anything about what the list is, how suppliers use the information, anything like that that's positive, that paints any kind of positive picture about what suppliers, why the information is valuable to suppliers. It just was a scare tactic.
Is there any objection to Delmarva's entering into evidence the dialogue that goes on between Delmarva and a prospective customer that was just referred to on the record? Not hearing any, no objection, it's submitted as Delmarva's next numbered exhibit, which I believe would be number 1.
Point of clarification.
Ms. Ivory?
We haven't had any exhibits yet.
That's why I said, which I believe is number 1.
Are we going to have our comments as exhibits, or?
I asked if there was any objections to the admission of the exhibit, and it was quiet in the room, so if you'd like to make an objection, please do so.
Point of clarification. The pertinent information in that exhibit is in the record as it was read by the attorney. I, as a personal note, suggested that Ms. Scott give it to the court reporter because she was reading it quickly to make sure that it was accurate. And I don't believe, it's obviously up to the commission, you can put it as an exhibit or not, but the pertinent portion is in the record now without it being admitted.
Well, Ms. Scott, do you agree with that?
I agree.
Okay, well, I thought you were walking up there, it was to be introduced,
No.
so I apologize, misinterpreted what you were doing.
Sorry.
So it's not introduced as an exhibit, and the words will speak for themselves in the record.
We need to vote on the motion?
We need to vote on the motion.
Yes.
Chair, may I ask just a quick clarification as to what you're voting on? The information that is that would be in the list as you're about under the motion, is that what the same information that Delmarva is currently providing in its current customer list that is detailed in A through G on whatever page this is? Okay, I just wanted to clarify.
Is there any further discussion on the motion of Commissioner Conaway? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, everyone. We'll have a 5-minute recess.
I'd like to do this.